The United States Department of Justice under Joe Biden has made a major concession in favor of the right to keep and bear arms. They are abandoning the field when it comes to certain historical analogs that in theory they could have used to uphold modern day gun control laws. This is a great development. It's a super geeky development, only going to be flagged by a handful, but because you turn into the Four Boxes Diner, you're going to know about it, and you will indeed be the smartest person in the room when it comes to the Second Amendment. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the campaign to disarm you and take your freedoms. Make sure you pick up a copy. This is a few years old, but it's still got a lot of great information in there about the full-blown plan of the anti-gun community to take our gun rights. Very detailed stuff. I think you'll enjoy it if you don't already own a copy. All right, folks. So major development here. Now, this is super inside baseball. It's very geeky. Okay, since NYSERPA versus Bruen was decided in the summer of 2022, there's been a debate among Second Amendment scholars and intellectuals about whether or not they can use, meaning the government can use, certain racist-based or nativist-based laws against like the Native Americans, the Indians, African Americans, the slaves, and the like, these sort of racist-driven laws that involve gun control. This was talked about actually in NYSERPA versus Bruen by Clarence Thomas to some degree in his opinion, where he discusses the Dred Scott decision before the Civil War, where the Supreme Court said that obviously blacks cannot be full-blown citizens of the United States because if they were full-blown citizens of the United States, they would be able to have the right to keep and bear arms, which meant that they could carry a gun wherever they went. And Roger Taney, in the decision for the Supreme Court, says that's not possibly the case, that blacks can do that. And of course, Clarence Thomas talked about how that was rectified by the 14th Amendment after the Civil War, allowing the freedom African-American slaves and all blacks to have equal rights, equal civil rights to all Americans, including the right to keep and bear arms. Now, with that context in mind, I want to remind you of the decision of Bruen and the standard that was set forth. And then I'm going to explain the academic debate about this, and then what the Department of Justice has just done, which is very good news for the right to keep and bear arms as I see it. Specifically, in NYSERPA versus Bruen, the Supreme Court set forth the standard for how lower courts, the inferior courts as defined by Article 3, are to interpret and apply and resolve Second Amendment litigations when there's a lawsuit brought to challenge a gun control law in 21st century America. The standard they set forth, in fact, they actually set forth the standard twice as follows. We've talked about on this channel many times. You start with the text of the Second Amendment as defined by the Supreme Court and any sort of necessary implications or anything that's associated with that. For example, again, like ink is protected by the First Amendment's right to free speech and the right to free press, even though the word ink does not appear in the First Amendment. That's the sort of thing we're talking about. So that's why things like magazines, modern semi-automatic firearms, and so on fall within the definition of arms at the textual level. So when you start with the text of the Second Amendment, as interpreted by the Supreme Court with the definitions, they've laid out all the definitions, like to keep means to keep, to possess, and to bear means to carry. Then after that, you ask, is the modern day gun control law that the government's trying to uphold, does that touch fingers with, is it implicated in some way with the text of the Second Amendment as interpreted by the Supreme Court? If the answer is yes, then the burden shifts to the government to justify that gun control law in a particular way. And specifically, just like when you are indicted or charged with a crime, the burden of proof is on the government to demonstrate beyond a reasonable doubt that you are indeed a criminal. You are presumed innocent in a criminal court. By analogy, in the context of Second Amendment litigation, when the text of the Second Amendment is implicated by a modern day gun control law, the burden shifts to the government in a particular way. Specifically, the burden shifts to the government to come forth with historical laws that were on the books and enforced at the time of the founding. It is the government's burden to show their actual laws at the time of the founding to justify any modern day gun control laws, to show there's a long-standing historical tradition going back to the founding of a particular kind of gun control law. These are not about talking about 20th century laws like stuff from the 30s. This actually means you have to go back to the founding era. Specifically, the Supreme Court laid this out as the standard, as we've talked about before. Quote, we reiterate, and remember, they said this twice. That's how important the standard is. The Supreme Court said it twice. Quote, we reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively, just like in a criminal court, right? The Constitution presumptively protects that conduct. You see what I'm saying? When in doubt, you throw out the gun control law. When in doubt, freedom prevails over gun control. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. However, the government must, obligatory, required to do so. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Historical tradition of firearm regulation. Not airy-fairy history, not storytelling by some 1619 supporter. No, a particular kind of law. Historical tradition of firearms regulation. They have to find actual laws on the books that were enforced. The nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command. Unqualified command. So for those of you out there that like to say shall not be infringed, the Supreme Court agrees with you because they write the Second Amendment's unqualified command, which is just another way of saying shall not be infringed. It means unqualified command. So that's the legal standard. Now, why am I telling you and reminding you this? Because the Department of Justice has made a major concession, as well they should, and I'm glad they did. That is, in the United States versus Rahimi case, their obligation is to show that the statute 18 U.S.C. 922 G8, dealing with those that are subject to restraining orders having to lose their gun rights under that federal statute during the duration of that restraining order. The government bears the burden because obviously that implicates the right to keep and bear arms because you're saying you can't have a gun during that period, which by definition implicates an individual's right to keep and bear arms here in the United States. So now the text is implicated. The burden shifts to the government, in this case the federal government, the Department of Justice, to go out there and show that there are historical analog laws on the books in 1791 that can justify that statute 18 U.S.C. 922 G8 dealing with restraining orders and you can't have a gun at the time. So we've looked at the Department of Justice brief. We've talked about this before, and you and I, we've all chatted about this in a couple videos already. But here's what's very interesting. Silence speaks volumes when it comes to the Department of Justice brief, or the dog that did not bark. You pick your metaphor. The Department of Justice has chosen not to argue, not to defend, not to cite, not to use laws dealing with laws that were gun control laws that were racist in nature, specifically racist laws that disarm groups like African Americans is an example, racist laws that prevent the selling of guns to Indians or Native Americans. I use the word Indians because that's what Supreme Court Justice Anthony Kennedy used in the context of the Heller decision and the Heller oral argument. So these laws that were technically gun control laws, they were gun control laws, but of course they were enforced against disenfranchised and unpopular groups. Guess what? The Department of Justice used none of these racist laws. They gave up all of these racist laws, which is correct. But I'm very glad they did it because, as you know, because the burden is on the government to come forth with historical laws at the time of the founding, every genre or category or group of laws at the time of the founding that we can basically kick out and get rid of as not being applicable reduces the number of historical gun control laws that the anti-gunners can use to justify modern gun control regulations. There were very few gun-related laws at the time of the founding. And to the extent there are any that we can show are racist in nature or anti-Indian or something like that, or odious in some particular way, well, guess what? If the Department of Justice and others, rightly so in my opinion, they should not be using these laws. They are motivated by ill will and racism and the like. They should not be used. If you get rid of these, that is very good news because, again, it gives the anti-gunners, the anti-gun community, fewer laws to justify modern-day gun control laws. So this is very good news that the Department of Justice has chosen not to use these laws. There's been a debate, a scholarly debate since 2022 about whether or not these kinds of laws should be used and can be used. And for those of you who are out there litigating these Second Amendment cases where you see the anti-gunner amicus briefs or the Department of Justice or the states, like whatever the state of New Jersey or whatever, to the extent any of them are relying on these odious or racist laws, you can point out that the United States Department of Justice refuses to defend those laws, does not consider those to be apt historical traditional laws that can be used to justify historical gun laws or whatnot. This is a very powerful concession by the anti-gun community and a very good one. Again, I think it's just morally right. I think it's legally right. And I think strategically it's very good for the Second Amendment movement. So this is great news. Now, I want to tell you what I think they're going to try to do in the alternative, and then I'll tell you the problem with it. What the anti-gun community, I suspect, is trying to do in the Rahimi case and beyond. And by the way, you know that standard I just read to you in this video? That standard was not typed up and inserted in the brief by the Department of Justice. Can you believe that? That the Department of Justice submits their brief to justify their federal gun control law in the Rahimi case, and they don't bother to actually set forth the actual gun law, the actual standard of the Second Amendment as articulated by the Supreme Court in Nyserpa versus Bruen. To me, not good judgment. Strategic call by the Department of Justice. Did they forget it? I don't know. Bottom line is, it's not what I would do if I were litigating that case. You always want to set forth the actual legal standard, and then you want to apply that legal standard to the facts of the case. And they didn't bother to do that. Kind of shocking, frankly, but nevertheless, it's their brief, it's their strategy, it's their call, so they do what they need to do because they're the lawyers, and I'm not for the Department of Justice. But let's carry on. Specifically, what the anti-gun community, I suspect, is going to try to do is they're going to engage in some very high-level, really analogies. They're going to try to draw analogies as what I call the 30,000-foot level, these sort of generalized abstractions, these general analogies, whatever you want to say, but this very, very high-level analogies is what they're going to do. To give you an example, what I think they're going to try to do is they're going to come to court and do things like this. They're going to say, hey, in 1791, there were laws against murder. They banned murder at the time of the founding because they wanted to discourage murder. We think this is a historical analog to modern-day gun control laws because we pass modern-day gun control laws today because we, too, want to discourage murder. That's where I think they're going to try to do. They're going to go with these kinds of very high-level abstractions, these very high-level generalized analogies to say, hey, laws against murder existed at the time of the founding. Now we can pass a gun control law against murder. Same idea. But the reality is, this is not what the Supreme Court's talking about in their standard. They specifically say you have to show that, again, a founding era law is part of the historical tradition of firearms regulation. It's got to be very specific to firearms regulation. It can't be just sort of a general view that something is bad and they have a law dealing with that. And I think if you look at what's going on in the courts today, a couple examples of where the anti-gunners are trying to get away with this very high-level abstraction or this very high-level analogies is trying to exploit the quote-unquote limited sensitive place restrictions that Nyserpa versus Bruen talked about. Specifically in the Supreme Court, in Bruen, of course, the Supreme Court says there were three specific sensitive places: polling places, legislative assembly, or legislative chambers, like Congress, and courthouses. And now you see there that places like New Jersey and New York are trying to take those very narrow exceptions, those very narrow sensitive place laws from the time of the founding, and expand out to say basically, half of Manhattan, that all of Times Square, they're like, hey, you can ban guns in courthouses because there's important things going on in courthouses. Therefore, there's important things going on in Times Square. Therefore, we get to ban guns in Times Square, right? They say, well, there's police officers in the courthouse. People go to the courthouse. Crowds congregate around the courthouse. Here in Times Square, people go to Times Square. There's police officers at Times Square. Important, interesting things go on at Times Square. Crowds go to Times Square. Therefore, we can ban guns. You see that very high-level abstraction, these high-level analogies to analyze, or I should say analogize, a courthouse, which is a discrete thing used for discrete time for discrete purpose, with like all of Times Square. That's the very broad level generalization that the anti-gun community wants to get with the analogies to justify the historical tradition of firearms regulations. Likewise, I think another example is this: at the time of the founding, because of the doctrine of in loco parentis. In loco parentis, that's three words for those of you keeping score at home. Under the doctrine of in loco parentis, basically says that adults stand in the shoes of parents when the parents are not around. And this was the case at places like universities, like the University of Virginia, because a lot of the students would go to these places and they would be 13, 14 years of age, very young, really children, going to these universities at the time of the founding. And the reason why I bring this up is there were specific rules and regulations that prevented the students from bringing guns and arms onto campus because they were so young. But this is not the sort of thing that you can say you can ban all the guns at, a campus in America, because you cannot ban the guns under the historical tradition when it comes to the adults, the teachers, the faculty members, the administrators, the adult visitors. You see what I'm saying? At the time of the founding, the historical tradition was limiting the students at universities from having firearms because they were so young, and the teachers stood in loco parentis, as if they were the parents, and they said, look, you're too young to have guns. That's basically all that was going on here. But again, what's going on is the anti-gunners are taking that very specific law at the time of the founding dealing with gun bans on students and campus grounds and trying to say that allows them to generalize as a general analogy to say that we can ban all guns on all campuses based on that very narrow example of students couldn't have guns because they were so young at the time of the founding, and the teachers were standing in loco parentis over them and saying, look, you're too young to have a gun on campus. We're not going to allow you to. We're basically your parents saying, no, not yet. You're too young. And again, but the anti-gunners are trying to do that general drawing of the analogy, and that is what they're trying to do. But the good news here, to sum up, is this: the Department of Justice has obviously made the decision not to use these racist laws, these anti-civil rights laws. I think that is great news for us because it's going to narrow the field of the number of historical analog laws that the anti-gunners can use to justify all of their gun control laws, including the ones presented in Rahimi. So again, every single battle that we can win, every genre of laws at the time of the founding that we can basically remove from the battlefield over our fight for Second Amendment rights is a good field, because once those analog laws, whatever the laws are, whatever it is that can be removed from the battlefield as not applicable or not useful to the anti-gunners, that's great for us, because remember, the burden is always on the government to justify their gun control laws, and every time we remove a genre of laws, that makes it harder for them to come forth with analog laws to justify them, because the truth is there's very few historical analog laws or historical laws dealing with gun control at the time of the founding, because Americans were free. We were a free country, and when the British tried to take our guns, we got into a fight with them and kicked them out. Right? Those are the people that gave rise to, among other things, the right to keep and bear arms. And of course, that history is mission critical to understanding what the Founding Fathers thought. And the Founding Fathers' view is critical because you have to understand what they thought to really appreciate the text of the Second Amendment, which is the right of the people to keep and bear arms shall not be infringed. Okay, folks, hope you learned a little bit something here today about some inside baseball fights over some of these issues involving analogies and abstractions. And if you haven't subscribed to the Four Boxes on it, please do. And if you think you've subscribed, please resubscribe, because we're getting some comments that people have been unsubscribed for whatever reason. So again, we're trying to get our numbers up there. All right, folks, we'll talk to you again soon here at the Four Boxes Diner.
Orders up. Table 2A.